Hello, Stephen Long here, broker in charge. I'm here to review the listing agreement with you guys, which just changed as of May 2020. So I'm going to pull that up and share my screen with you. And we're going to review the current listing agreement. So I am in Zip Forms. If you're not familiar, this is the Zip Forms platform. It's free to you as a realtor member. As part of your dues that you get this software and forms. So real quickly, I always like to reference that if you have further questions or details not covered in this video, there's a fantastic document called the guidelines for this form. Your offer to purchase, buyer agency agreement, and listing agreement all have these guidelines, and they are very excellent resources for you. They have a lot of additional explanation and information that I may have missed, so feel free to reference those if you have questions or something that I didn't address. Likewise, I will always be available if you want to shoot me a message or get in the comments. I can share something there with you if you have a question. All right, so without any further ado, let's get started. This, by the way, is the exclusive right to sell listing agreement. There are different flavors of the listing agreement, but we're going to talk about the exclusive right to sell listing agreement, and where you identify the seller here and the firm here. So this will be the seller here. Remember that if you are putting in a husband and wife, you will need both of their signatures. Again, 1 to buy, 2 to sell. Anybody who has an ownership interest should be listed as a seller. If you are working with an estate, you need the executor. The executor needs to have permission to sell real property on behalf of the estate. If you are selling for a trust, you will need the trustee's signature as well. You will still name an LLC, trust, or estate here, but you will need the signatures of the requisite person, i.e. the trustee, member manager, or executor. So you'll need all of that information, or executrix if it's female. So also in the listing firm, make sure the listing firm is the firm in which you work for. Whomever the check will be made to goes here. Some of you are on teams, you're a firm within a firm, that's fantastic. Don't put that here. The firm that will receive the money goes here. That's a long story, but in short, if we put 2 firms here, so your team and the firm you work for, and you may have a dual agency situation, but yet we have 2 different firms. Well, we know from pre-license, if you have 2 different firms, you cannot have dual agency. So which one is it? Dual agency with 1 firm, or do we have 2 firms? So a lot of you are with teams and you're a firm within a firm. So really the firm that you are within, the 1 firm, will go there. So put that there. Remember to always look at the boxes. And if you have an estate or anything like that, always check with a legal advice, get the appropriate attorney to review it. So you're not entering into an invalid listing agreement. We want to make sure we have the correct persons as our sellers before we move forward. Also make sure that the term of agreement as we defined here are explained. The effective date of any agreement, but particularly this one, is the day that everybody signs it. So the sellers both will sign it, you will sign it. That is the effective date of this listing agreement. If the property is currently listed for sale with someone else, meaning the seller has called you, the seller solicited you, we would not solicit a listed property because that's an ethical violation. If the seller solicited you and you are now entering into a listing agreement to begin at a future date, you would say that their listing expires on this date, and that is when your listing agreement becomes valid. All listing agreements, just like all of our contracts, will have a start and end date. This will be then the end date. So here's where we're starting, here's where we're ending. Be very, very specific in your legal description. If you've seen my offer to purchase video, it does cover the reasons for this. Make sure that you do define the address as best you can, and likewise use as much of this legal description as possible to be very clear. Deed book and page are usually a minimum requisite. Make sure you also pull the deed book and page to make sure that it does describe the property in which you're selling. And while you're there, look for anything on that deed that might be a red flag for any water easement, shared wells, mineral oil, gas rights, or anything that might have been severed. I had one that had uranium rights. You never know what you're going to get. So check out those deeds. Make sure you reference the deed book and page. Feel free to use this other section. This is where I like for you to write things. You know, the house and 4 acres located at the corner of Walnut and Main. Put that in there. That's perfectly okay. And again, you may or may not have a plat book and page for every property, but deed book is for sure a good place to land. Make sure we go over fixtures and exclusions. You need to be having candid conversations with your sellers about what is a fixture. It seems no matter how many times we define it, they tend to want to take something. And a lot of times it's something like a plant. It seems like it's always a hydrangea. The hydrangea was at somebody's funeral and we want to pick that up and take it with us. Well, a plant is rooted to the property it is a fixture unless we are going to remove it, in which case I recommend removing any fixtures that are not going to be conveyed prior to listing so that we don't have to worry about negotiating those, because inevitably someone was making an offer because they loved that hydrangea bush, and now that you're taking it, we don't want to give you as much. Let's go ahead and get that out of there if we can. This goes so far as to give you a list of suggested fixtures so that if there's any question, it kind of is a reminder to help you go through and talk about, security systems. That's a big one now. Smart devices like Nest thermostats, cameras, Ring doorbells, all those types of things that need to be addressed when you're taking the listing of what stays and what goes. And remember, if it's bolted, screwed, attached, rooted in any other way, shape, or form, glued, it stays unless otherwise specified in the contract. As a word of advice, remember anything that is listed as something that would not convey here, we get it to the offer to purchase and contract. So while it is beautiful here on the listing agreement that you and your sellers are entering into, if it does not get transposed to MLS and then subsequently to the offer to purchase, it does not matter. I have been guilty of that myself. So make sure if it ends up on the listing agreement, it ends up on the offer to purchase, or it will end up hitting your bank account. Also, make sure you identify any items that might be leased, for example, security systems or fuel tanks. Those would be not subject, they're not able to be conveyed by the seller because the seller doesn't own those. If there's any personal property that the buyer or the seller wishes to transfer to the buyer at closing as a part of this listing agreement, we can include that here. There is the option for a seller to have a home warranty. If you so choose, you can put a home warranty on the property at the time of listing. If that is the case, make sure you do disclose that they are getting one. And if there is a marketing fee or anything being returned to you, you would disclose that here as well. Also, the listing price, most important, do not put TBD. This is very important to fill in the actual listing price and the terms in which the seller will accept it. If they're not willing to accept FHA, VA, or USDA or some other option or seller financing, don't check that box. You may want to explain or need to explain what each of those looks like. On paragraph 7, we're going to talk about how much you're getting paid. Now, this is the firm, the listing firm's compensation. Remember, the listing firm is entitled to all of the commission. So let's just say for round numbers, this is a 10% amount. So the listing firm would receive 10% of the gross sales price, or you could put a flat amount, whatever that amount may be. Of course, due to Sherman antitrust, we are not discussing. Remember, all commissions are negotiable. I am simply using 10% as a round number. Feel free to use whatever you and your firm have as a policy or what you guys charge. We are not price fixing here. We're just using a round number of 10% to go there because I want to illustrate that this is the total amount of commission that the seller will be paying. Also, this is a protection clause that says if within a certain number of days, whatever you put there, if the property sells to any of the persons that you were responsible for procuring, they would still owe you a commission. You would likely need to document those persons. Also, remember that the fee may be due if the seller ends up in breach or if they fail to sell the property as agreed upon. You could still be entitled to your commission if that happens. Also, I wanted to bring attention to number 8. This is where I wanted to talk about that 10% that we just mentioned. If there was in fact a 10% fee being received to the listing firm, this is where the listing firm is disclosing how much of that 10% they are willing to share with what we would call a co-broke or an agent of another firm. So if someone is working as a sub-agent, how much of that 10% would you share with them? If someone is working as a buyer's agent, how much of that 10% would your firm be sharing with them? And then lastly, if I was going to have a firm policy drafted, I would just check that box and say, see attached, this is what we do. Now, our firm duties, you are an extension of the firm. So whatever your firm you are working for, these are the duties at which you are so subscribing. Basically work hard to find a buyer, disclose material facts, even if the seller doesn't want you to. Important to have that conversation. Also, you are a real estate broker. All other professional services should be directed to the professional in their respective fields, including tax, surveyors, structural engineers, inspectors, and anybody else that the seller may need for advice. And we can certainly make recommendations for those folks. We just aren't those professionals, unless you are. You might be an attorney. Some of you are or otherwise, and you can practice in your respective fields that you're qualified. We also provide this agreement to the listing service. So if in the event the MLS needs a copy of this, we are getting that authorization to share. Sometimes that may be necessary in the event of a commission dispute or otherwise. So we will have the seller's permission to share that. This is new, so if you're familiar with the old firm, you will miss this initial. This is the bold, capital, non-discriminatory language that is present in all of our agency agreements as well as the offer to purchase. And now we have gone so far to make sure that the seller initials this, because I know it is unfortunate, but too many sellers tend to make decisions on people instead of the terms. I myself have run into this where a seller has seen the name of a buyer and decided that they wanted to be discriminatory. And of course, I had to kick them to the curb. But now we need to have that conversation on the upfront, because that would save me a lot of marketing if I was more clear with that expectation. Who knew if you have to tell people not to be a bigot, but you do, and you're going to initial it. Lastly, marketing. We're going to talk about what you can and cannot do in this capacity. Again, as a listing agent, you cannot market, tweet, talk about, or even so much put forth that you are listing or have a property coming soon until you have a listing agreement, because this next section tells you what you are authorized to do as their listing agent. Hey, listing agent, you are allowed to submit it to the listing service. You are allowed to place signs, put an open house, have coming soon advertising if we so agree, and most MLSs will likely have a coming soon rider or addendum that will go with that. If I'm putting it on the internet, what does that look like? Now I skipped this section right here, but I want to come back to it. This is the commencement of marketing. If you're due to the new clear cooperation that is put forth by NAR, and the reason this form was resolved or refined, I guess, on May 5th, sorry. The reason we got a new form in May is because of this clear cooperation agreement that NAR put forth. And it says that you will put all of your listings in MLS, i.e. cooperate, within 1 business day of taking this listing. So within 1 day of this form being effective, signed by you and the sellers, you will have it in MLS. If that is not possible, if we are not yet ready, go ahead and get your listing agreement signed, but check this box and note the date that it will become live or will start the marketing. So 1 business day from whatever day you put here, then it should be in MLS. Now keep that in mind, because there's another box we'll come to in a minute that says, well, what if I don't want it in MLS? We'll talk about that. Reminders and internet, if you're going to engage in internet advertising, it is going to syndicate to websites outside of our control, like the Zillows, the Trulias, the Realtor.coms, and places that we may not have control over. It's important, I think, to tell your sellers on the appointment that, yes, we're going to put it out there, and there are going to be websites that pick up our information, and some of which we can't get changed. So you might see it wrong in some places. That's not my fault. I didn't do it. They just syndicated the fields wrong, or they copied it from tax records or otherwise, and will request that we correct it, but there are no guarantees. This is where we're getting permission to put a lockbox on the property if they allow us to. The seller is going to acknowledge that lockbox and make sure that we are controlling those visitors. Make sure that you tell them that taking pictures and videos of anyone at their property is 100% permissible. However, it may very well be a federal crime to record any oral communication. So if the audio is on and they are recording or listening to that audio, they could be in violation of federal law. Not so cool. So if they want to have surveillance cameras to keep an eye on the property, that is certainly their prerogative, but they should not have audio on those cameras, because that can get them in real hot water. So make sure they understand that as well. Make sure they also know to lock up any valuables they have. If it's firearms, medicines, jewelry, whatever the case may be, if you don't want it gone, don't leave it there. Put it in a storage, put it in a safe deposit box, put it somewhere besides where we are going to be opening your home to the public. Now, I did mention a minute ago, if I don't want it in MLS, I don't want it there, then I can do an office exclusive listing. Now, keep in mind, this is an office exclusive listing. So only the firm listing this property can have knowledge that it is for sale. We cannot be sharing it, marketing it, syndicating it out otherwise. This is a box you would check here saying that if the seller is going to withhold that consent to be put in MLS, because it's in their best interest, their seller best interest not to be in MLS, they are allowed to do so. It also says the listing firm may be required to provide documentation of that being the fact, and they may very well have to sign an addendum saying that that's okay, because it should be syndicated within 1 business day of public marketing. If a public marketing of an exclusive listing is not permitted or applicable, then the delayed marketing date should be left blank above. So if you're not going to be delaying, or if it's not going MLS, you do not have that delayed marketing date because you are effectively listing it on your effective date. It's just not going in MLS. Please check with your broker in charge, your firm, your MLS for your respective policies on how they want this handled. I know many MLSs want a form in conjunction with this type of office exclusive listing stating within 1 business day, it's either going in MLS, yes, we're doing that, or within 1 business day, you're going to tell them why it is in your seller's best interest to have an office exclusive listing, and you have to submit a form documenting that. So you may or may not have that option in your local MLS, but I know most of the ones I'm affiliated with do. This goes over earnest money and talks how it will be held in trust. In the event of a dispute, it does get held in trust and could be released to the clerk of court. We do have that termination of contract when the time comes, if it's necessary, and it will determine whether it's being released or not. We will talk about whether or not the seller has to have flood insurance and is in a flood zone. Now, keep in mind, being in a flood zone is different than having flood insurance. It is possible that the seller may own their property free and clear, and their lender does not require flood insurance. That does not mean they would not be in a flood zone or a partial flood zone. So this is where we're asking the questions. We will always, of course, do our own due diligence. Check ncfloodmaps.com for more detailed information. But this is where we're asking them if whether you are located or whether you're not, or whether you have flood insurance. Same thing with synthetic stucco. Are you aware of that? Is there a homeowners association? What's their contact information? Do we need, remember that the new construction owner association may not be required if it's a new construction, or if it's well, it wouldn't be a foreclosure most likely, but in this case it could be. So make sure we have conversations about that. And at the seller's expense, they may need to get some additional addenda as well. Let's see. Continue talking about the HOA, get all their information you can there. Termite bond is necessary to ask about this. A termite bond is different than a termite treatment. A termite bond means I pay a fee every year, and if termites ever show up, the termite company will treat it for free. That's different than when I bought it, someone come out and sprayed for termites, or someone comes out and sprays for bugs. Those are different. Termite bond and termite treatment are 2 different things, so we're going to ask about those. Most of the folks I know don't typically carry a bond, but they may very well, and if so, what was that amount and with what company? This is where we're talking about the disclosure of how long the seller has owned it, 1 year or less, 1 year or more, or does not yet own the property. We're going to give them some samples. Any form you fill out that has a box that says seller receives samples, check the box, give them the samples. You can email them, it doesn't cost you anything. So give them an offer to purchase as a sample. Give them the copy of professional services disclosure and election form. I like to give it to them and say, this is going to be a checklist that the buyer is going to be looking at as they perform their due diligence to all the potential and possible inspections they want to do, from radon, accounting, and appraisal, etc., and answer any of their questions about that. So check those boxes, give them the forms. We're also going to ask them about their payoffs. Now, this does not have to be precise. What I'm looking for is, do you have a mortgage? And if so, about how much are we looking at? Because if I can get the account and information to get the payoff, then we can give that to the attorney if needed, but I don't really need that. I just want to know, do we have a short sale? Is this a capacity where we are selling this for enough money to get you out without you having to bring money to the table? And if you do have to bring money to the table, do you have access to that money? So I want to make sure I run a net sheet and give you an idea based on probable sales price where we're going to land in that capacity. Also, if there's any information required for, are you in a default, or are you in bankruptcy, foreclosure, are you behind, any of that information we want to ask, and they can fill out any explanation there. If they're under bankruptcy or not, check those. If there's any leases subject to the property, we want to know about that. Do you have a tenant in it? Do you have partially rented, any written or otherwise enforceable leases that might be available? Remember, in North Carolina, oral leases are actually enforceable. So make sure you ask. If they just say, hey, I just have a handshake agreement, well, that may still be a lease. We may need to get information and communicate that. There might be a property manager if it's managed by someone else, and we can put their information here, in which case that alerts us to get information about maintenance, repairs, security deposits, lease information, etc. This is to go over the FHA appraisal. Remember, an FHA appraisal will actually stick to the property for up to 90 days, depending on the lender, but it will always be in that database for up to 90 days. So if the seller has had one done recently, we need to know about it just as an awareness and make sure that we are, if it is in fact below list price, that is material. So we need to know whether that's necessary or whether we'll be even able to accept an FHA financing. Any special assessments, as we talked about in the offer to purchase, are going to be the responsibility of the sellers. And so we're looking for any proposed or confirmed assessments here so that we know what might be standing out there that needs to be paid, and then make sure whomever is going to pay it. Example here might be a sewer assessment that's coming through that has been paid or might be collected in installments. A neighborhood with maybe condos, they're going to be rebuilding the decks, and every unit gets a $500 assessment paid and $100 over the next 5 years. If that's the case, identify it here, and then whether or not it is confirmed. If that is confirmed, then the seller will pay that. If it is proposed, then we want to identify it here as well, and that would be the buyer's responsibility. If we're listing a manufactured home, we would identify that here and find the what we call the HUD plate, or the VIN, vehicle identification number. This is typically going to be located inside the cabinets of a mobile home, stamped somewhere on the frame of the mobile home, or on one of the outside corners at the vinyl siding. You can find what we call that HUD plate, and it'll have the information you need here. If they have any titles or documentation, we want to ask questions here. A very important question when listing a manufactured home is, has the title been relinquished? If the title to a mobile home has not been relinquished back to the DMV, then you are essentially selling a car sitting on land. And we want to make sure that whatever needs to be done to get rid of that title and affirm that that now mobile is no longer mobile and attached to the property and treated as real estate. So I have been in a case where I've been a listing agent, second or third listing agent, and no one asked that question, and come to find out it had not been relinquished. So we had to walk the seller through what that process looked like so we could sell the mobile home and the land as real estate, as real property. Fuel tanks, are there any fuel tanks? This is really important, especially underground fuel tanks. Ask that question. Sorry. Are there any available? Excuse me. Are there any on the property? Are you aware of any? Were there any when you bought it? Did you put any in? Did you have any taken out? Fuel tanks are a hot button. Ask a lot of questions, and if there are any, get the respective information here. The seller is going to make sure that the property is available for showings. They're going to keep you informed. They're going to cooperate with marketing. They're going to allow buyers the opportunity for inspection. They need to ensure that they can convey clear title. Typically, they will be providing a general warranty deed. In the event that is not the case, maybe it's a trustee's deed, special warranty deed, or otherwise, you can certainly make that correction here as necessary. If there's any restrictive covenants on the property, bylaws or otherwise, check with their title insurance, make sure that they don't have any surveys or other information that might be beneficial, and we can share that. Also, remember that sellers are actually now responsible for sharing any material facts that they may be aware of about that property that would not be revealed in a buyer's normal process of due diligence. That is a kind of an overlooked ideal, that while the seller typically sells as is, where is, caveat emptor, buyer beware, if there is something they know about that property that would not be discovered by material or by a reasonable due diligence, home inspection or otherwise, they're actually required to show it or to share that, or they could fall in the category of fraud. If you want more information about that, I have a couple of posts on my Facebook page, the Notorious BIC, that I have, that has some case studies where that actually came up, and the buyer sued the seller basically because they put lipstick on a pig and covered up some rotten stuff that they knew about, and it would not have shown up in any home inspection, or no one would have discovered it. But in fact, they did discover it later. It was a big issue, and the seller, the now owner, went back and sued the previous seller and won. So if there's anything that they need to share, now is the time. This goes over home inspections, and I always encourage the seller to get a home inspection at the time of listing, and if so, they agree or do not agree to get one, and that is a great opportunity to help discover material facts. Go ahead and give them a copy on that question. The answer on home inspection is put forth by the Real Estate Commission. It's an excellent brochure. It's free. It's PDF. You can download it from NCREC.gov. It's also in your forms. Check that box. Give it to them. Talk about all their photographs. My conversation going over this with the seller is that, Mr. Seller, I'm going to take pictures of your home and every square inch and video, and anything in it could go anywhere in the world. So if there's anything you don't want the whole planet to see, let's get it off the walls. Let's get it out of the house. If you have medicines, you have guns, you have your kid's name, you have college degrees, you have your college favorite football team, whatever. Let's get that out of there so that it doesn't go all over the world. For example, you might have your favorite college on the wall and your degree, and your security questions might be, where did you go to school? Well, I can look at the MLS photos and make that determination and get the answer. So that's a safety thing. Be very careful and share that will be the case. It's going to go out everywhere. Any other additional terms that you may have, you can write in here. Some people charge a termination fee. Maybe if you're going to terminate early or otherwise, you can put some kind of additional. I have a 24-hour easy exit clause that allows my sellers to get out in the effect if they find that I'm not doing my job or they're dissatisfied for any reason. They give me 24 hours to fix it. And if not, then I will allow them early termination without penalty. This goes over agency. I don't want to spend a lot of time going over agency because hopefully you know that and know how to explain the working real estate brochure. Just remind them that as a dual agent, you are a referee. You cannot coach them unless it becomes a designated agency situation, in which case, if you are a designated dual agent, you can coach them to the nth degree and are expected to. If you're truly acting as a dual agent, you can call a fair game, but you're the referee. You keep them within the confines of the rules, keep them between the ditches, but you can't coach or advise. So then down here, we're going to tell them that they are either going to allow you to act as a dual agent or no, I don't get that dual thing. I want exclusive only, meaning, by the way, if you are going to list it as exclusive only, no one at your firm can show their buyer agents that property, and you need to inform everyone at your firm that this seller desires that exclusive representation and that they can only represent the seller as a sub-agent and showing that property, not as a buyer or dual agent. Now, they could opt, if they do opt for dual agent here, they could additionally option in or opt in for designated dual agency. Of course, I'm not going to spend a lot of time further explaining that, but that would be a conversation you would have to have and let them initial one of these two options and possibly this one if they are okay with that as well. So make sure you get those initials there because that's very important. This says that we have the right to mediation in the event we have a dispute between us or the other parties, and we can reach out and get the professional to mediate or arbitrate, mediate before we arbitrate or litigate. Wire fraud disclosure is on your offer to purchase, it's on your listing agreement, it's on your buyer agency agreement. Never, ever, ever email wiring instructions. If you get the opportunity to help them with this, again, tell them you will not email it, let the attorney pick up the phone and call them. As I mentioned in my offer to purchase video, it's a great opportunity to have them wire a few dollars to the receiving account, pick up the phone and call the receiving account, the attorney, in fact, and say, did you get the X number of dollars? Or maybe even have the attorney tell them what amount was wired so that they can confirm it was accurate. And then wire the remaining funds so that you know it is all going to the correct destination. Take some wire fraud classes, do some risk management there, guys. It's a huge issue. Don't brush over that portion. Go over, make sure you're initialing as well because you are entering into this contract on behalf of your firm. And if you have missed an initial, we want to make sure we get your initial and the seller's initial right before we get to the signature page. This also goes over the entire agreement and defines all the issues associated with any changes or terminations being needed to be documented in writing. And we each acknowledge a copy of this, and you should make sure they get a copy of anything they sign. All clients and your firm get a copy of all executed documents within 3 days. So listing agreements, working on real estate brochures, buyer agency agreements, offer to purchase, anything signed and executed by everyone necessary, you should provide them copies within 3 days. Many of our electronic signature programs are doing that instantly, but make sure they get a copy and you also get it turned into your broker in charge in your firm for review within the same 3-day period. Be sure to fill out your information, specifically your license number, who are they engaging in as a firm, and your contact information as well, so that you have your firm, your license, and your information as well as the sellers on this agreement. Without any further ado, I think that will wrap up our conversation of the new listing agreement. The biggest change, if you're familiar with the older one, I have a quick video on that, but you do have that initial by the non-discriminatory language, and likewise we have the addition of the office exclusive listing and the rules that go along with that. So again, I'm Stephen Long, and I'm broker in charge here in North Carolina, and I do have a Facebook page, the Notorious BIC, if you want to follow along there, where I vomit all of my fun real estate musings. Otherwise, Feel free to comment, call, text, email me. Glad to help you any way I can. Hope this was helpful.